Mention is there. Mention also. May I please, your lordship? Lordship, I beg to mention item number 9 and 10, lordship. Lordship, may I kindly adjourn the matter for today, lordship.
Sorry, please, the lordship. 9 and 10.
Yes, lordship.
The date reference matter.
You are the appellant in.
Reference, I'm there, and he's for the.
Item number 10,
accused.
I'm for the appellant.
Item 10.
Yes, lord.
10, he's
Your
for
good
the.
name, please.
Zedas on behalf of Mr. A.K. Bhuyan.
On request made on behalf of Mr. A.K. Bhuyan, learned counsel for the appellant in criminal appeal 336 of 2018. Please, after 2 weeks.
May I please, lordship? That's why I beg to mention item number 11, your lordship.
Please, your lordship. I beg to mention item number 11.
11. both of
Yes,
you.
yes.
Item 11.
Yes, what do you want?
Pass the matter for today, lordship.
Lordship, it may come after 3 weeks, your lordship.
You are appellant.
Yes, lordship.
Your good name?
KM Kakoti, lordship.
You are appearing on behalf of.
KM Bora, lordship.
on
This
request-
item, in this item, I think the records are not here. It was sent for additional evidence. I don't know whether it has come back or not. But we'll see after 2 weeks. then.
Okay. On request made on behalf of A.M. Bora, then the counsel for the appellant. This the matter after
3 weeks, lordship.
3 weeks.
Bless.
Apply.
May I please, your lordship? Lordship, I just to mention item number 15, lordship, of daily list. Lordship. Yesterday, we have informed lordship, and we have taken consent from all the sides, lordship.
You appellant in.
Lordship, we are for respondent, lordship. This appeal against acquittal, lordship.
Anybody for appellant?
Lordship, we have taken consent, lordship, yesterday, lordship.
On request made by Mr.
Ayu Chaudhary, lordship.
Ayu Chowdhury and the council correspondence 2 to 7. List the matter after
Lordship, after view vacation, lordship. Any date, lordship.
the BU.
Lordship, another pair, lordship, item number 6, lordship.
Item 6.
Lordship, I am appearing on behalf of G Chaudhary, lordship. Today he has some personal difficulty, lordship. Just few minutes back, lordship, he informed me, lordship.
I don't know. You have not given the slip yet.
Lordship, that's why, lordship, we.
Yes, Jahan, what do you say?
In fact, this is a leave application.
Lord.
The condonation was heard before it was allowed.
Lordship.
Today it has come up for leave. This is my appeal, state's appeal against acquittal. If he is not well, let it come up after 2-3 days.
Third MS says Jahan, Leonard additional PP. On request made on behalf of G Chowdhury, Leonard counsel for respondent 1 and 2. In criminal appeal 95 of 2023. List after 2 weeks.
Lordship.
Yeah.
Howla, lordship.
May it please, your lordship. Lordship, I beg to mention item number 13 of the daily list, lordship.
Yes,
Lordship, kindly adjourn the matter for today, lordship.
you are for?
I am for the appeal and J. Hatimuria, lordship.
14 is analogous.
Yes.
Lordship, we have also taken consent from the Learned Council item number 6.
On request made on behalf of J. Hatimura, General Counsel for appellants in the for the appellant in criminal appeal 252/2019. List of the 3 weeks.
Obliged, lordship.
May I please, your lordship? Lordship, I beg to mention item number 12, my lord. Madam, I will pass over for the day, my lord.
You have Mr.
EU Khan on behalf of A. Ahmed.
On request made on behalf of A. Ahmed, General Counsel for appellant. List the matter after.
Obliged.
The pursuant to the interim order, one of the petitioner has been admitted.
Only one.
Yes. My
How
lord,
about the other two?
my lord, no, regarding the third one, my lord, there was a slight modification of that order.
Okay.
And regarding the second, my lord, we could not have any instruction. But my lord, for the present, my prayer is, my lord, since my lord, the admission for the next session is also going to be held in, start in the month of May. So I'll pray, my lord, the matter should be disposed of, my lord.
There were three.
Well, I
seats,
can appreciate it may not be today, my lord.
There are 3 seats which should be kept vacant. So one of the seats here they got. We told, my lord, it is not in our hand. Ultimately, it happened that it is in the government of India. Portal has been opened, and accordingly, my lord, the seats have been given. Number 2, already she opted to a different college. I think he's got in Shillong somewhere. She got admitted. Second is concerned. And third, there is an order of this court that whoever get the highest, the better marks, then they, of course. So that was the order. So my lord.
And my lord, now the matter needs to be heard. Of course, my lord, this is covered by an earlier division bench, therefore it will not take very long. If your lordships would kindly have this matter on, my lord. We are going for vacation. Oh, here, hafta to no hobo na?
So May somewhere first week. May first week.
No, no, my lord. May first it begins. Could it be on either 26th or 28th, my lord? Time wise, it may not take long because it is already covered by the earlier. bench.
I'll argue that matter. That is another judgment. I'll show it. Well, let it be then. It's in May. Then the 20th.
No, my lord. May what happens? May the process starts.
What he's saying is
28th
April.
April.
26th or 28th, my lord.
28th of April. 26th there is difficulty. 28th.
Okay.
28th.
For final disposal, my lord.
Heard Mr. K. N. Jyoti, the senior counsel assisted by.
Yes, Chakrabarti.
Actually, the
Yes, Chak-
process is started. Exam, all this will take long time because ultimately this is under your lordships. It has been moved before this court. It's under scrutiny of the court. Process.
For the petitioner. Also heard Mr. Dida.
My lord, may I please interfere? Actually, my lord, I'm counsel for that, the one who filed IA. My lord, actually, I am compelled to assist the court, the very recent development. I've come from Aizawl. So my lord, I had filed IA, this IA number 468 and 469. 468 is for implement, leave to implement, and 468 is for modification. My lord, actually on 6 January, mistakenly order was passed, allotting seats to those who got lower mark. So I got higher mark. This one
So
got,
what they are saying is that has been rectified.
No, my lord.
my lord, actually,
My lord, my learned friend cannot have an order in my writ petition. If he wants any relief from the court, let him file an independent writ petition.
Yes.
As an OP, he cannot seek relief in my petition.
my lord,
My lord,
actually,
as long as my lord, my learned friend should understand the nitty-gritties of law, my lord. That's why to the extent of petitioner number 3, the order is modified.
Also
my
heard,
lord, one thing is that is not what I want to say, my lord.
1 minute, also heard Mr. Didas, Leonard Advocate General Mizoram. Stop. On request made by the parties, list this matter for admission hearing you want?
Yes, my lord.
For admission hearing on 28th of April.
Yes.
28.
Deeply.
I please,
Respond by 8, Lordship.
Mr. K. Gogoi, Leonard CGC.
Lordship.
appears for response.
Lordship, I am appearing for respondent numbers 3 to 7, Lordship.
And
It's
Mr.
A. Chakrabarti, Lordship.
J. Chakrabarti, Leonard counsel.
I appear for,
1 minute.
I appear for IA
Respondent
applicants.
3 to 7.
My lord, I appear
Mr.
for the applicants.
C. Lalun Sangha,
Yes,
Leonard counsel. Appeal for the applicant in IA number
IA 46
468 of.
and
2020.
469. My lord, may you please once make submission, my lord? Only one submission.
I pass orders.
My lord, actually, that,
Come back on 28th.
my lord, it's very urgent now because portal is open, admission is in the process. So I would assist the court. If I make submission on this report, I would definitely assist the court.
That's why we are listing it on 28th April.
My lord, that time admission may be lapsed.
No. Is it lapsing or before that? No.
But during these days, my lord, actually, my client has to get admission because that one, the class already started long time back, December.
Oh, that is under the scrutiny of this court. I think there will be no problem.
Yes.
Because it's under the, this matter is litigated, it's under the court. That's a.
My lord, the thing is that if one direction be given. My lord, one thing that now list number 2, she declined. There are 3 vacancies. She declined. 1 vacancy is kept open now. The government is in dilemma because now.
Lalun Sangha, I've already passed orders. Come back on 28th.
Yes, my lord. Actually, I was not heard before passing the order.
Doesn't matter.
Or
We'll hear you on 28th.
Yes, my lord. Then allow me, my lord, allow me to submit IA.
I've already passed orders.
Yes,
Councils have already gone.
yes.
Item 4.
It's an appeal. Jail appeal.
Lordship, yes, jail appeal.
This is an appeal from jail. Which call for the LCS. Informants,
It's not made a party here.
let the LCR come with.
Lordship will decide.
Registry is directly to operate an application of the complaint. This conduct after 4 weeks or 6 weeks.
After receipt of the LCR or 4 weeks.
4 weeks.
Five.
May it please your lordship. My lord, this is a statutory appeal, my lord, against the judgment and order dated, my lord, 31/2023, passed by the learned special judge Pokso Sibsagar, convicting the appellant under section 6 of the Pokso Act and sentencing him to undergo rigorous imprisonment for a term of 20 years and to pay a fine of rupees 10,000, my lord. So at this stage, my lord, appeal may be admitted and notice may be issued to the respondents 1 and 2, and also LCA may be called for, my lord.
1 minute. Yeah, Mister,
Yes, does, my lord.
what as does the counsel for the appellant? Admit. Call for the
My lord, in this matter, my lord, there is also an IA, my lord, for suspending the sentence.
appellant to take steps. For several of public on reform number 2. By registered within 1 week. MS Jahan and it appears on behalf, Assam appears on behalf of respond number 1. List the matter after 4 weeks.
And my lord, in the IA, my lord,
Will consider on the thing.
IA, my lord, the respondents may be directed to submit written objection.
That
I'll file it within 2 weeks.
depends on.
Yes, much obliged.
It's the filing number.
This has not been admitted yet.
Lordship, which one? Item 5.
Item 7.
7.
May I please, your lordship? This IA is for condemnation of delay, my lord. How it has happened, my lord, this delay, I have explained in para number 2, my
How
lord.
many days?
It is 13 days, my lord.
I have no objection, Lordship can.
13 days.
Yes, the father, my lord.
Heard Mr. S. Tabata, learned counsel for the applicant. Also heard MS Jahan, learned additional DP for the opposite partner for the sole applicant. By this application, the applicant is praying for condonation of 13 days in filing the connected criminal stuff. We have considered the court shown in the present IA and we are satisfied. Stop. MSH Jahan has also now been report the delay of 13 days in filing the criminal is condoned. IS disclosed not. Register to list the criminal
Register the criminal.
direct to the district attorney. That is the method.
Admission. For admission.
I'm deeply obliged.
8.
May I please, your lordship?
Again, a delay of
128 days, your lordship.
128 days.
I'm using that normal bit. Yes, please.
So Lordship, condemnation of delay of 128 days, Your Lordship.
You want to file objection?
No, Lordship.
Jail appeal.
Let it be heard on merit. I think this is 302.
Yes,
You are Mr.
A Hussain, Your Lordship.
Heard A. Hussain, let us counsel to the applicant. Also heard MS S. Jahan, let the additional PT for the sole opposite party. By this application, the applicant is praying for continuation of 128 days in the filing of criminal record. We have considered the fourth one. MS Jahan, and I think that's also not good. According to the period of 128 days in filing, filing connected criminal appeal is unknown. IS report. Registered directly to registered criminal in the
Yes.
civil process.
Item 16, hearing.
Please, Your Lordship, my senior is on legs in another court.
What can we do now?
I think her senior is for the informant. And the petitioner advocate is Mr. Rupjit Dey.
Are they?
R Day. He is not there. I informed him yesterday also.
Is your senior the appellant?
No, my senior, Mr. B Prasad is for the informant. Informant. Mr. Day is for the petitioner. Yesterday I informed him, in fact, about this case.
Hmm.
He said he'll come. Lordship can take up the next matter in the meantime.
Yeah, meantime, let us see. Pull up the next case.
Who is it?
17,
Nobody is there, Lordship. I've gone through the entire paper book. Lordship, I think no case has been made out against the accused appellant. May fairly submit. No evidence, my lord. Only the informant, who is the wife of the accused person. Her allegation is that that the accused person has killed his baby, 42 days old baby. But there's no evidence. Immediately, she has not informed the police. There's a delay, Your Lordship. And certain witnesses are deposed that only that Sangeeta, who is the mother of the deceased victim, Your Lordship, and the wife of the accused person, she has informed. That much of only information is given. Apart from this, there is nothing, absolutely nothing on record, my lord.
So what do we do now? Let us give him a date.
Yes, Your Lordship. I think it's not a jail appeal.
He should come.
I think he is on bail, my lord, because it doesn't say, paper book doesn't say it's a jail appeal.
Yeah, it's not a jail appeal.
Maybe he was, may I check the records, my lord? No, IA. This case. May I check the IA, Your Lordship, if any IA is there?
One I is 584. This has not been disposed.
This is for delay. One more IA is there, I think. Or can IA, sir, this?
Okay.
Lordship, no application for bail?
No. I don't know what IA is that.
Other one is for condonation of delay, 583.
Okay, that is for bail, I think.
One for early hearing, 5/1/2022. This is the IA 584. And 583, your lordship, it's for condonation of delay.
That's all.
What's this one? Yes, no other eyes.
Delay is condoned.
Yes,
Okay.
probably this person is,
584 is for bail, I think.
584, lordship, yes. Yes,
So that means
but there is no order.
he's not on bail.
He's not on bail.
Then he should come first.
Yes, your lordship. May I pray, your lordship, an amicus curiae be appointed? If the person, lordship, if your lordship finds out there is no case against the accused appellant, lordship, then his personal liberty will be curtailed, your lordship. May I fairly submit?
Even the amicus curiae may take some
Yes,
time.
my lord, it can be appointed. I'll leave it to your lordship, my lord, because B. Borgohai, S. Gogoi, JP Kosari.
I don't know these councils, whether they are regular.
Yes, lordship. B. Borgohai is the senior man who asile. B. Borgohai, oh. Oh, lordship. Lordship, may I submit? 5/1/2022 order. Mr. JP Kochari, learned counsel for the applicant appeal, submits that he would not praise IA but makes a request to post the connected appeal for early hearing. So.
Okay, we list up the two.
Lordship. কৰিবা ন? কৰিবা ন? ফটো কোৱা।
Please, your lordship. Regarding 302, whether life sentence.
Is item, you are on item 17?
70, lordship.
Yes.
But I'm not fully prepared, lordship, any day next week, lordship.
Lordship, today is Tuesday, আজি কি Wednesday.
Wednesday.
বেয়া হ'ব ন?
Kindly, I'm not fully prepared, lordship.
You are Mr.
JP Kosari, lordship.
JP Kochari, learned counsel for the applicant. It's the matter. After 1 week.
1 week, lordship.
My lord.
Okay.
I may be wrong in submitting, but I did not find out any material, your lordship.
You study your case.
Yes, lordship.
Personal liberty of your client
Yes, lordship.
is involved.
And probably this is a 2018 criminal appeal. Maybe he's in jail. 4 years have gone by, and during the trial, FI is of 2012. Kali কৰিব নেকি?
Next week.
Oh, Lordship, he is not interested. Let it be.
Would have been a good day for you.
Yes. Okay. All right.
Sixteen.
No, Rupjit, Day is not here.
None appears for the applicant. MS has done the. This doctor,
Lordship?
this doctor,
List after 2 weeks, 2 weeks or one, anyway, after Bihu, it will go, I think, because next week there is program, then Bihu. After Bihu, perhaps
2 weeks.
2 weeks. List is exhausted. Not even 11.
Normally, this bench is always like this.
Not always. And initially it happens. After that it picks up. My lord, R. Mojumdar is appearing for elementary. He's on legs in court number 1, my lord.
How long is it going to take?
I don't have any idea, my lord. He's arguing in the matter, my lord. It's going on.
Wait for some time. Wait.
This is that matter, Lordship.
Yeah, Mr. Ken Chowdhury.
Chaudhary appearing, Lordship. Lordship he is coming, Lordship. In the last occasion, Lordship, I think the petitioner council has concluded their arguments, Your Lordship. So before Lordship is coming, Lordship, can I make a similar submission, Lordship? Regarding the maintainability, Lordship, in the writ petition, Lordship, my senior will join thereafter, Lordship. In the writ petition, Lordship, kindly see the Lordship, the prayer portion, Lordship. Here, Lordship, I will not trouble you by reading the prayer portion whole, Lordship, but in this, my appointment order is not under challenge, Your Lordship. Yeah, Lordship, the respondent number 12's appointment order is not under challenge, Your Lordship.
You are responding to us.
I'm respondent number 4. He is for respondent number 12.
He is representing governing body.
Governing body.
Oh, you are the. But the
Lordship, the respondent
proceeding
number,
is challenged.
Lordship,
The proceedings are challenged.
for proceedings are challenged, Lordship, but thereafter, Lordship, as per the Lordship, the norms, Lordship, the appointment order ought to have been challenged either by in case of IA also, because it's a different cause of action, Lordship. And in my affidavit, Lordship, I have annexed the appointment order also of respondent number 12.
Where's your affidavit?
Respondent number affidavit of opposition filed by respondent number 4, Your Lordship, on 11/8/2022.
Yes.
Kindly come to Lordship, page number 40, Your Lordship.
Running phase.
Not running page, Lordship, perhaps. It's
Sorry, my lord.
No problem.
Respondent of 12 appointment order is not under challenge.
May it please, your lordship. My lord, my friend Mr. R.P. Sharma has already made his submission. Yes. Now, my lord will, the matter relates to, my lord, the selection of respondent number 4. No, sorry. Respondent number 12 as the principal of the JB College, Jorhat, my lord. And here in this case, I am appearing on behalf of the respondent number 4. Now, if your lordship will kindly come to page number 38, my lord, of the affidavit in opposition filed by respondent number 4.
Yes.
97, my lord. Yes. The meeting of the governing body of the Jagannath Barua College held on 18/4/22 at 2 p.m. adopts the following resolution unanimously. The governing body resolves to accept the recommendation of the selection committee under chairmanship of Professor L.K. Nath, Honorable Vice Chancellor of the Dibrugarh University, to select Dr. Utpal Jyoti Mohanto, Associate Professor, Sibsagar College, Joysagar, for appointment as the principal of Jagannath Barua College, Autonomous Jorat. Further resolves to request Director, Higher Education, to appoint Dr. Utpal Jyoti Mohanto as regular principal of Jagannath Barua College. So this was the resolution, my lord. Thereafter, my lord, by letter dated 19/4/22, my lord, the governing body of the college wrote to the Director of Higher Education, my lord, for approval at page number 98. I have the honor to submit here with the particulars of Utpal Jyoti Mohanto in connection with his appointment as principal of Jagannath Barua College. The candidate has been selected for the post by selection committee under so and so. The governing body of the college in its meeting held on 18/4/22 resolved that DHC Assam be requested for appointment of Utpal Jyoti Mohanto as principal vice Dr. Bimal Bora, retired on 31/3/22. Then, my lord, at next page, my lord, page 40. In exercise of the authority conferred under proviso to Rule 5(1) and 7(a) C of the Assam College Employees Provincialization Rules 2010, and on the basis of the recommendation of the selection committee and governing body's resolution number 1 dated so and so, the undermentioned person is hereby appointed as principal of GB College with the following terms and conditions. So, my lord, 27/4/22, the director appointed the respondent number 12 as the principal of the college. Now, my lord, this appointment has been challenged by the proceedings has been subsequent appointment is not under challenge. The proceeding, my lord, by which the governing body took the resolution, that is under challenge in the writ petition. Now, my lord, the case of the petitioner is, if your lordship would kindly take the writ petition, my lord. If your lordship would kindly come to page 18. In the premises aforesaid, it is therefore most respectfully prayed that your lordships may be pleased to call for the records and issue a rule calling upon respondents to show cause as to why a writ in the nature of circular should not be issued, to quash and set aside the impugned proceedings dated 11/4/2002 of the respondent authorities in forwarding the name of the respondents to the principal, etc., etc. So, my lord, in spite of the fact that from the affidavit filed by the respondent number 4, it has emerged that subsequent to that, the proposal was accepted by the director and he was appointed. Yet, my lord, the appointment is not under challenge. So here is a case, therefore, my first submission is where the consequential orders have not been challenged. It is only the initiation of the process which has been challenged. Now, my lord, that the petitioner's ground of challenge is that there is something wrong in this selection. What is that wrong, my lord? Well, look, these are all selection made by experts. Lordship knows the law on the point very clearly. The Supreme Court has all clearly said, my lord, when a selection is made by the expert, unless, my lord, there are gross arbitrariness, or supposing, my lord, some weightage is given which a particular person is not entitled to, in such a scenario, it will be a different situation. Otherwise, my lord, your lordships will not substitute the view of the selection committee, number one. And more pertinently, my lord, he has participated in the selection process. He never raised any objection at any point of time. Only when he is unsuccessful, my lord, now he is assailing the selection. So, my lord, it will be very difficult for your lordships to accept the challenge of the writ petitioner, my lord, because there are two principal propositions of law which are against the petitioner. Number one, you having participated in the selection process without any demur, now merely because you're not successful, you cannot turn around and lay a challenge. And secondly, my lord, the selection has been done by expert. Unless you can show that some mark has been given to me which is not entitled to me, Otherwise, my lord, where is this code? In that view of the matter, now I'll draw your lordship's attention to my affidavit, my lord. If your lordships would kindly come to para 3 and 4, my lord.
Yes.
Page 62, my lord. C. That the interview for the post of principal of the college was held on 11/4/22, wherein total 7 number of candidates, including the petitioner and respondent number 12, had appeared before the selection committee. The selection committee, after following the proper procedure as laid down in the relevant statute, had prepared a consolidated statement of marks obtained by the candidates appeared in the interview for the post of principal of the college. A perusal of the said consolidated statement would go to show that the petitioner had obtained 62.30 mark, whereas the respondent number 12 had secured 69.99 marks. It is stated that respondent number 12 has scored highest marks than other participants in the said selection process. On the basis of the guidelines laid down by respondent number 2, by OM dated 23/8/13, the selection committee had selected and forwarded the name of respondent number 12 for appointment in the post of principal of the college in its meeting dated 11/4/22 to the governing body to accord approval for this said appointment. Then my lord will kindly come over to page 65, my lord, F. That the respondent number 2, who had order dated 27/4/22, appointed respondent number 12 as president in exercise of this power. Then G, my lord, after issuance of order dated 27/4/22, respondent number 12 had joined the college and had taken over charge of the regular principal of the college on 28/4/22. Now, if your lordship would kindly come to page 65, my lord, H. That the principal secretary to the government of Assam Education Department issued OM dated 15/12/21 prohibiting government employees who are selected and appointed for any state government service under Education Department as teaching and non-teaching staff from applying for any other state level government service in the same position grade up to a maximum period of 3 years. By way of the said OM, earlier OM dated 25/6/16 was superseded. It is stated that the Commissioner Secretary to the Government of Assam Higher Education by a OM dated 25/6/16 prohibited incumbents selected and appointed in a state government service with effect from 1/8/16 for applying for any other state level government service in the same position grade up to a maximum period of 3 years. It is the pleaded case of the petitioner that he was appointed as regular principal of CKB Commerce College by order dated 19/8/19. As such, on the last date of submission of the application form, that is 23/3/22, the petitioner did not complete 3 years of service in the post of regular principal of CKB College. Therefore, in terms of OM dated so-and-so, petitioner was not eligible. So, my lord, there is a circular by Government of Assam, my lord, which your lordships will get at page number 44 to the 102, my lord. Education Department, Government of Assam is pleased to notify that any government employee who has been selected and appointed for any state government job under Education Department is not allowed to apply for any other state level job in the same position grade up to a maximum period of 3 years. And in case it is detected at any stage that any such state government employee has violated this OM, an appropriate departmental action will be against the concerned employee. My lord, as far as this OM is concerned, my lord, I personally don't vouch for this OM, my lord, because supposing a man is in some employment, he can always apply for a post through proper channel, my lord, by seeking no objection from his employer. But then, my lord, there is one more thing has been added to this. If somebody violates, then he is liable for disciplinary proceeding. not only the petitioner here, my lord, he will not get he cannot compete. For applying his, has been incurred disqualification, that he can be proceeded departmentally also. So it's a debatable issue, but nevertheless, it's an OM issued by the government, my lord. So therefore, it is binding on him unless he challenges this order. Now, my
This,
lord,
CKB Commerce College.
yes,
Is it
he's a regular principal.
Government college.
Government college, it's same aided college, my lord. Of course, status of JB college is slightly different now. It is or something like deemed university type. Now it is an autonomous thing, my. Initially, Cotton College was a government college. Now it is an university. Now government must be thinking of improving the status of JB college because it's a premier institution of Upper Assam. So, my lord, fact of the matter is this OM has brought in a restriction on a sitting principal to apply at least for a period of 3 years. So that is one thing, my lord, which also needs to be gone into by your lordships. Now, as far as the challenge in the writ petition is concerned, only ground is that I do not have the administrative experience of 15 years. That we have dealt with, my lord. If your lordship will kindly come to para 8. It will be like My lord will kindly come to paragraph 8, my lord. One of the allegation of the writ petitioner, which we have dealt with, page 68.
Yes.
That while denying the statement made in paragraph 11 of the writ petition, the answering respondent begged to state that the API score of respondent number 12 is 256.48. The respondent number 12 has 12 number of research publication in journal with Scopus site in his name, whereas minimum requirement is 10 number of research publication. It is stated that as for the advertisement, there was no requirement for an incumbent to appoint as neither coordinator of internal quality assessment committee, nor does incumbent has to be a PhD supervisor as claimed by the petitioner. Further, it is stated that respondent number 12 had served as head of the Department of Physics at Shivsagar College on 2 occasions with effect from 1/2/2007 to 30/11/2012 and 1/4/2019 till date of his appointment as principal of the college, and has gathered total 8 years and 8 months of experience as HOD. The records will reveal that experience of serving as HOD is also counted as administrative experience. As such, it is categorically denied that the respondent number 12 does not have the administrative experience as alleged by the petitioner in paragraph under reply. In fact, the petitioner had made such incorrect statement before this honorable court with a view to mislead this honorable court just to get a relief which the petitioner is not otherwise entitled. So these are the 2 points which he has raised in his writ petition, that I do not have research publication, and secondly, I do not have the experience. My lord, the supporting materials are also annexed in the petition, my lord.
এইটো petition নাই তো sir extra হয় এইটো মই application আৰু মই জনো submit কৰিছিলো
এইটো ৰেকৰ্ডত থাকি ওলাব
ৰেকৰ্ডত
এখন কি
এইটো হৈছে স্যাৰ আমাৰ ৰিসার্চ পেপাৰছ বোৰ ৰিসার্চ জাৰ্নেলছ বোৰ আৰু এইটো হৈছে টোটাল API স্কোৰ যোনটো আমাৰ 256 হয় নাই বুলি কৈছে আমাৰ 10
My lord, this is what we submitted before the college, this flag, my lord.
respondent 12 কৰিছে
Respondent number,
respondent 12
respondent number 12 is submitted, my lord. I have this, I do the flag. Hey, I do the DDS. 796.
দুটা এই দুটা ফটো
মই তাক দিয়াটো কোনটো এইটো ফটো দি দিয়াচোন ফটো দি So first, one of the allegation is I do not have the requisite research publication. And secondly, my lord, I do not have administrative experience that I have met. I'm relying on two judgment, my lord, I have given, if your lordships would kindly have. First, my lord will have 2016 1 SCC 454, my lord. My lord will kindly come to paragraph 12. If your lordships would kindly come to placitum F at paragraph 12, my lord. It is well settled that the decision of academic authorities about suitability of a candidate to be appointed as an associate professor in a research institute cannot normally be examined by the High Court under its jurisdiction, having regard to the fact that the candidates so selected possessed all the requisite qualification and experience, and therefore their appointment cannot be questioned on the ground of lack of qualification and experience. High Court ought not to have interfered with the decision of the institute in appointing respondent number 2 to 4 to the post of respondent professor. So I am relying on the judgment for the proposition. Normally, lordships will not interfere with an expert body's findings. Yes, if in an appropriate case, one can come up with, materials to show that no, there are certain prerequisites which are required to be fulfilled. If the expert body ignores those, certainly lordships can interfere. But my lord, normally, I haven't seen the difference between the marks, my lord. I got 69.99, he got 62. There's a difference of 7 marks. It is a huge difference. And secondly, my lord, he having participated in the other judgment, my lord will kindly come to the other judgment, my lord will kindly come to paragraph 18, my lord. Placitum, between placitum G and H, the sentence starting with, it is settled legal position that courts have to show deference and consideration to the recommendation of the expert committee consisting of members with expert in the field if malice or arbitrariness in committee's decision is not forthcoming. Doctrine of fairness evolved in administrative law was not supposed to convert tribunals and courts into appellate authorities over the decision of the experts. The constraint self-imposed undoubtedly of writ jurisdiction still remain. Ignoring them would lead to confusion and uncertainty. Jurisdiction may become rudderless. So these are the words of caution, my lord, which Honorable Supreme Court has said. My lord, in the other judgment, at paragraph 15 to my lord 16, 17, the apex court dealt with, my lord, once you having participated, then my lord, you are not supposed to turn around and say the grapes are sour. Para 15, 16, 17, my lord. The first two paragraphs are for the proposition that, my lord, normally lordships will give due deference to the views of the expert unless some arbitrariness, some shortcomings are, my lord, shown. And secondly, my lord, you having participated, you never raised any of these objections. Anyway, my lord, you may have a grievance that it is your perception that you have fared well in the interview. And my lord, the marks which has been allotted, these are not based on any subjective material. These are based on objective consideration because there is an office memorandum which governs how the selection is to be made. So based on that, my lord, it was done. Even if your lordships will kindly have a look at the marks, my lord. It starts from, my lord, page number 76. Page number 76, it starts, my lord. Eventually, it ends at, my lord, page number 84. If your lordships would kindly come to page 84. Sorry, I'm sorry, my lord. Page 85. Page 85, my lord. Serial number 5 is the petitioner Ranjit Sharma. He has got 2.30 and respondent number 12 has got 69.99 selected. So prima facie, my lord,
Respondent 5 is serial number 7.
respondent 12, my lord.
12.
Yes, serial number 7. So he selected. So there are 9 persons involved in the selection process, my lord. It is not possible for the respondent number 12 to manage all the 12, my lord. 9 persons. They all applied their mind. They are all given these marks. So therefore, in this view of the matter, my lord, my humble submission is the writ petition is devoid of any merit, my lord. It is liable to be dismissed. That is my humble submission, my lord. Deep level. The lordship's kind permission.
Well, I am for a respondent number 12, my lord. I will adopt, my lord, argument advanced by learned senior, my lord. And my lord, I have all the eligibility criteria, my lord. I have
1 minute. 1 minute.
all the conditions, my lord, and
Yeah, Mr.
RM Decca, my lord.
RM Dekka. Chowdhury is assisted by Mr.
TJ Das.
J.J. Das.
My lord.
Yes.
My lord. Government.
My lord, I am appealing for higher education department, my lord. Records were called for, record is with me, my lord. I have flag mark to the my lord, consolidated marks and the my lord, research experience and as well as the my lord, administrative experience, my lord. My lord, as per the records, the respondent, the private respondent has 12 publications, my lord, which containing ISS
1 minute. Yeah, Mr.
S Das, my lord,
S. Das.
higher education.
According to you,
Respondent
12.
12 has, my lord, research publication, 12 research publication, my lord. I have tag mark, my lord. I will pass the record, my lord. And he has also administrative experience also, my lord.
Yes.
If I may pass the records. please. Well, the yellow mark is consolidated marks and thereafter, my lord, green. And on the green flag marks, my lord, there are research publication and the administrative experience there, my lord.
May I please your lordship, I am appearing for respondent number 5 to 11, members of the selection committee, and I adopt the argument at
Yeah, MS.
R. Kakoti. And I adopt the argument advanced by my senior counsel, Mr. Chaudhary.
Yes.
Lordship, we have submitted our application, lordship. Lordship will retain it or lordship?
No, you can take it because government record has it.
Yes, lordship. It's the same
Yes,
thing, lord.
petitioner?
Lordship, as per my knowledge, Lordship, RP Sharma has been assisted by Mr. D. Dole, I think, Lordship.
No, that is okay, but whether they would like to make a reply.
ফোন কৰি সোধা ন না না পাব।
Can you close the matter of the petitioners council? Give it back.
My friend has got to inform her. I've been informed that he is coming, your Lord.
It's coming. We better close it then. There's no point.
Yes, Lordship. Moreover, Lordship, we have responded, everything the
The
records are
only
there.
question is whether he wants to make a reply, that's all. In his absence, I can't record his presence also. This is the whole issue.
Main problem.
Yes, Mr. Sharma, are you making a reply or not?
Yes, I will make my 100%. We are confused because yes, for notice my there are 3:30 sitting.
Mhm.
So
No, it says 3:30 or whichever is earlier.
yes, so I was in different court model. Today is coming the file. I'll reply. I was short reply. 5 minutes reply. Yeah.
He pointed out one thing.
Scope also actually good. What is it? কি করো তোমাদের? What is your argument? Huh? কি কি argument? Yeah. Hmm? কিন্তু কিন্তু
Basic argument is,
Hello?
basic argument taken is
Yes.
from the other side. Is that you have not challenged the appointment order of respondent number 12.
Yes.
The nitty-gritties of the selection process, which has been made by an expert committee, need not be gone into by the High Court.
Without mother?
Should not be gone into by a High Court.
Yes.
When it is not an appellate authority. Basically, that's it. And then you participated in the selection process
Yes.
without any objections.
Yes.
And therefore now you cannot turn back and challenge the.
Yes.
selection.
Right, man. So, my lord, I participated. After participation, only I came to know the selection committee was biased. Some of the members were biased against me. That's why on 13, my lord, there are some guys again come to third annexed to page 25. On 11/4/2022, my lord, there was the selection committee sitting where I participated. Before that, there was no scope for me to know.
Page?
Page my lord, 25.
Yes.
I immediately submitted an application to the director, my lord, saying that an appeal against the any approval to the proceeding region of the selection committee held on so and so, or so and so, college, or where I have strong apprehension that I may not be selected for appointment. So this was our apprehension, and here I said, my lord, that there was bias and objection was raised by me on the second day itself. This is important. Otherwise, without knowing this, the process of selection and the attitude of some of the members, I could not suspect before sitting in the interview. So that reply will cover, my lord. And I have given the detail, 25, 26, 27 pages.
Yes.
And my lord,
Proceed.
yes. So, my lord, I have raised the doubt, my lord, apprehension, and I prayed that he should be given personal hearing and sending back proceedings dated for of the selection committee, page 27, for review of the same without approving it from your end. I raised strong objection, my lord, immediately. Now, my lord, they have said scopus. They have got, my lord, 10 papers. That is admitted by respondent 4 in paragraph 8. He says they 10, but scopus site, we have cited, my lord, downloaded from the scopus site, my lord. It is only 9 papers he has got to his credit, whereas I have got 19 papers publication to my credit. As per the scopus site, annexer M1 and M2 to my reply. Yes. And the response 4 in paragraph 8 of this counter has admitted that 10 is required, but this was shows 9. Your Lordship, kindly come to page 129. Annexure M1. No, take it. 131 or something. Left hand column. I had argued my last time. Left hand column top.
That I've seen.
Yes. Metric overview. 9 documents by author. Yes, Lordship, got knowledge. But 10 is the requirement as per the UGC regulation. M2. Page 131. I have got 19 publication. Left hand, sir. Has Lordship got knowledge? 19. On this count itself, my lord, he is not qualified to be called for interview. But since it was I alleged bias, and this scope site cannot be manipulated, is an international site, my lord. Uploaded by the UGC.
What
So-
do you say about the office memorandum?
My lord, yes, office memorandum, patently, my lord, is illegal because you cannot restrict under Article 14 and 19 of the Constitution of India.
That is not under challenge.
No, my lord, this need not be challenged. When is my lord ex specie? What even CEO? My lord, I have perhaps did not bring the book, my lord. I just cite two judgments, my lord. 1981 for SCC, Hasani. 81 for SCC and 74. No. 1981 for SCC 421. Plus, I'll give the book, my lord. No, even no. Then, my lord, 1974 to SCC 121. This, my lord, and these two, one says, my lord, when any order is expressing body ab initio, violating the fundamental rights, any legal rights, then it is not to be challenged. It can be ignored. And the 1974 Samalot in collateral proceeding also. The order came saying, not the main proceeding, collateral proceeding. Here, my lord, they have said that I have not challenged the appointment order. What is my prayer? Lord's my kindly come to prayer.
I've seen your prayer.
Yes, it's very comprehensive. The proceeding that is so and so, and the responsible so and so, and or any action proceeding to accommodate the responsible 12 to the post of principal Jubilation, Surat, and further to show cause to. So collaterally have challenged because at that time the order was not given to me when this was filed. Subsequently only I received order. But I was against the very selection process. If the selection goes, everything goes. There is the root, and the appointment is the tree or the branch. And so far is that there is this memorandum. If there was a bar at all, they will examine my application. They knew my data. For more than 2.5 years, I was the principal of the CKB college. They are not saying, why did you call me? You cannot appropriate and reprobate, my lord. That is the approved, my lord, phrase by the Honorable Supreme Court, following from Scottish law. It is 1956. 1956, my lord. Supreme Court 593, paragraph 21. Once you approve it, you cannot apply. Otherwise, you will be punished. Then you can reprove it. Paragraph 21. And there, my lord, in this judgment of 1956, Hillsbury's Law of England is also quoted, my lord. Volume 8, page 464. I will give the note, my lord. I will prepare the note. There, my lord, once you reprobate, that amounts to stipple against you. Suppose I say, no, you cannot come to my house. Then I invite him. Then that creates not only reprobation, but also stipple against me. I have to respect that. In that manner, I cited 1956 Supreme Court. And manner, this 2001. 2001 5 SCC manner 629. What is waiver and acquiescence? It was a lottery case matter from Sikkim. Lottery case from Sikkim matter. What happened? Sibbai Associates had a huge due of payment to the Sikkim government. But he was given extension and he paid some amount. Later on again, Sikkim government cancelled his license. That was challenged. So, my lord, there the Supreme Court has said 16A, my lord. This one, paragraph 16A, my lord. I will give the judgment, my lord. I have got with me. Median. Okay. Page 645. 16A and C. Last word,
Yes.
the conclusion in the award are found seriously vitiated on account of gross misreading of the materials on record, as well as due to conspicuous omission of the draw necessary and lawful inferences. Inevitably flowing from the indisputable material as well as the findings of record by the arbitrator himself. Conclusions directly contrary to the indisputable fact placed on record are shown to have been drawn on the question of alleged waiver, throwing overboard the well-settled norms of criteria to be satisfied and proved before the plea of waiver can be ever countenanced. Leave alone the basic and the fundamental principle that violates the reciprocal promises cannot be crowded with price of the defaulter. So, here what happened, the waiver plea was raised, but since he was again defaulter, but then the Supreme Court dismissed his petition. And the waiver is defined, next page, page 646.
Same paragraph, long paragraph continues, my lord. Last paragraph. Whoever involves a conscious, voluntary and intentional relinquishment or abandonment of a known existing legal right, advantage, benefit, claim or privilege, which except for such a waiver, the party would have enjoyed. The agreement between the parties in this case is such that its fulfillment depends upon the mutual performance. This is not important, but only definition of the waiver. So once you waived and ultimately participate, that goes, my lord. This judgment I'll place. Then, my lord, what else was the submission? These are the points, my lord. And my lord, that the High Court in writ cannot sit in appeal. That is accepted. Series of umpteen number of cases are there, so Supreme Court and Divisional High Courts. But unless there is malafide is exhibited and alleged in the petition, I have alleged malafide not once, not twice in my throughout, right from the petition, in the application, in the reply. And interestingly, my lord, he has not, the respondent 12, who is the affected party, who would be affected if the judgment goes against him. He does not counter, my lord, the specific statement of my writ petition about the qualification, about ineligibility, nothing, just denying. That is not enough. It must be a specific denial. Because the 1993 Nasim Banu case says, non-denial, not countering, would amount to admission. That means he is not qualified. Since the respondent 4 had filed affidavit on his behalf also, questioning, saying that Scopus site there must be 10 publications. He has got 9. We filed reply. Then also he didn't counter that I've got 19 publications and he has got 9 only. Then also he's silent. Means he wants to play hide and seek. Because he would be affected. Nasim Banu case is, my lord, 1993 supplementary 4 SCC 46. Paragraph is 9, 11, 12. Dear my lord, that unless there is, my lord, one judicial member case, selection case was there.
Yes. Anything else?
Yeah, my lord, now, my lord, that court cannot sit and appeal unless there is malafide alleged. This is the judicial member selection case from Madhya Pradesh, my lord. Perhaps it is not reported, but it is online. I have obtained, my lord, of Supreme Court judgment. Anil Bhardwaj versus State of Honorable High Court of Madhya Pradesh. Here, paragraph 20 and 21, 22.
Where's the judgment?
I will give. There you go. I have, my lord, on the top, I have just written with pencil, my lord, there may be exhibit. Ultimately, since there was no allegation of malafide in the said petition, my lord, so Honorable Supreme Court dismissed his case, but we have got specific. Anil Bhardwaj versus Honorable High Court of Madhya Pradesh, my lord, because it is Pawan here. Paragraph 21 and 22.
Yes.
Then there is another.
Yes.
And similar line matter, Madras High Court judgment matter. This is also online matter. G. Gopal Kailasam, the Excellency Governor of Tamil Nadu. But here, G. Gopala Sarayan and the Governor of Tamil Nadu. Paragraph 7-8. Same. Paragraph 7, madam.
Yes.
56 Supreme Court, your lordship has got, my lord.
Yes.
Now, my lord, the UGC regulation of 2018, my lord, framed under section 26 and 14 of the UGC Act 1956, my lord, that is statutory regulation. Copy this, a copy is there given, already given, my lord. Page 61.
1 minute. Copy.
Yes, full copy. Full copy was given, my lord. Entire
Yes,
regulation.
yes.
Page 61, my lord. Kindly turn. Roman 5, my lord. V. College principal and professor. Professor grade. Yes, lordship, my lord. Eligibility criteria. Number 1, PhD. I have got 2003 PhD degree, my lord. He has got 2016 or 17, and it is not clear. Your lordship will kindly examine the record whether he had taken any permission to go for higher study for obtaining PhD. If it is not, he will be liable for punishment under Rule 13 of the Assam Conduct Rules 1964. Then, my lord, 3, Roman 3, small Roman 3. Minimum 10 research publications in pre-review or UGC listed journal. And minimum 110 research score as per so. He has got 200, 58 API. I have got 316. So that way also I am much better qualified and already holding the post of principal, my lord. So there could not be any reason to disqualify me. And the very marking pattern I have pointed out, my lord, on the day, where in the objective matter, 1 year, 1 marks. I have got 13 years of administrative experience, 10 marks, 9 members, 90 marks I should get. I will give only 64 marks. 8. Guideline is my page 29 of the writ petition. 28, 29. Guidelines on marking. Annexure E. As per the guidelines, my lord, head wise it is given. They are subjective marking also that
Yes, yes, I've seen.
is 29 as well also got my lord.
I've seen.
Yes. My lord. The year 3, Roman 3 is 10 marks for each year. Then my lord, ability to communicate effectively 10 marks, full marks. Since he is principal and about 28 years of service, my lord, ability to analyze and discuss curriculum and development agency. He was a PhD award professor. Here he guided 3 students already, they are out PhD, and the response is none, 0. And ability to analyze and discuss college development and administration, 5 marks. And I am IQR coordinator in. So I've already given page 56 onwards all my qualifications. And he has not given anything in his reply, affidavit, counter affidavit. Totally silent, what he is, where from he hails, what is identity. Record may be examined, my lord, so.
I have the records.
Yes, there are lots of kind.
But Mr. Abhishek.
And my lord.
May I submit lordship to submission, lordship? Lordship, with regard to the Malafide lordship, the application that my learned senior counsel is relying on, that is of 13/4/2022, whereas the selection process initiated in 2020 itself. At that time, lordship, there was no submission, lordship. There was no allegations about Malafide or anything. Just after the proceeding, just after the 11/4/2022 proceeding, lordship, they have filed this application alleging Malafide, lordship. And moreover, lordship, regarding the OM, lordship, the acceptance that the governing body has accepted his application, because the OM was of 2021, your lordship.
Yes.
And the records will reveal, lordship, that I have 12 journals, lordship, not 9, lordship. That's all.
Heard Mr. R.B. Sharma, limit senior counsel. Assisted by Mr. R. Dolly, isn't it?
Yes.
D Dole, Lord.
D Dole, D
D.
Dole.
Dolly,
That will be
counsel
D
for
Dole.
education. Also heard Mr. S. Das, the standing counsel higher education. Mr. Kian Chowdhury, the senior counsel. Assisted by Mr. DJ Das.
DJ Das, lordship.
For respondent number 4. Mr. R.M. Deka for respondent number
12.
12. And MS R. Kakati for respondents 5 to 11. Hearing concluded, just 1 minute.
Obligement, deeply obliged.
Much obliged.
Quickly, Peter. We'll sit at 2. Report.
Item 1, 2, and 3.
We'll consider it too.
My lord, these matters would need a little bit of recapitulation on my part also, because it was argued quite some time back.
Yeah.
So I'll have to go through the entire thing again. Perhaps there'll be some time constraint now. My preliminary, if it will be taken up on 3rd or 4th. Otherwise, or in the second half today, my lord. If it's
April
convenient.
3rd, 4th. This will be all busy
Yes.
days. So you want, we can try on the last week of April.
Yes.
This will be too late.
No.
I didn't.
On
On the 11th of April.
See, there is a program on 14. We're quite busy there. These 2 weeks, let us be careful.
My lord, that
It will be
this
on
should be the last opportunity, my lord,
Yes.
because
Yes.
Only LP में जाना है. LP school, you participated. वही क्या दिक्कत है?
But Mr.
all Oscar.
All Oscar, Learned Counsel for Petitioner. On request made by R. Majumdar, then Standing Counsel, Elementary.
Elementary, my lord.
Education.
Hmm?
List the matter on
27th is a hearing day, my lord.
27th
27.
April.
I'm also appearing for MCT.
Mr. J. Alam.
I am.
I Alam.
But kindly it may be recorded that this is the last.
The last.
This is a part heard matter, so.
Appears for the NC.
I mean, again, it is coming, but
Yeah,
हम लोग complete कर ले, तुम complete कर, where is timing again?
Majumdar, we are not.
No, I'll do it, my lord, I'll do it.
Need to-
27. Obliged.
We'll continue at 2.
তারাটা বস্তু তাহলে ফালতু কথা যাকে যাকে একটু তবে তেল মেরে থাকো মাঝে মাঝে কত জিকির আছে দেখে তো মানে কিন্তু হয় না আর ফলে হয় না একটু হয় বলে বলে বা আমি
requesting the later to take needful steps for declaring the results of the candidates belonging to the BTR and SCHAC, along with the candidates who are out of the jurisdiction of the BTR and HCHAC, NCHAC. After hearing the learned counsel for the parties and also on consideration of the letter dated 24 November 2022, the principal of the Assam Survey and Settlement Training Center is directed to declare the results of the 6 months RCCC training, which was held from 1st of November 2019 to 6th of October 2020, within a period of 1 week from the date of receipt of the copy of the order of this court. With the aforesaid observations and directions, this writ petition stands disposed of. Lordship, what has happened? The Honorable Court, Lordship has passed this order basing on this letter dated 24 of November. Your Lordship, before this 24 of November letter was issued by the Assistant DLR, there was another letter, Your Lordship, which was dated 9th of November. Lordship, if Lordship peruses page number 105, the last page of the review petition, Your Lordship. 105, Annexure D.
Yes.
Lordship, that is the letter dated 24 of November. Going through this letter, Lordship has passed the disposal order, Your Lordship. What has happened? There is a reference, Your Lordship. Your letter number such and such dated 9th of November 2022. There is a reference, Your Lordship.
Yes.
So, Lordship, this letter dated 9th of November was not placed before Your Lordship.
Where's
While,
that letter?
pardon, Your
Where's
Lordship.
that letter of 9th
Lordship,
November?
that is as annexure C 104, page 104, the previous page, Your Lordship. Lordship, may I read this letter?
Yes.
Lordship, this is a letter issued from the principal, Assam Survey Settlement Training Center, to the Director of Land Records, Your Lordship. And the subject is non-declaration of results of the RCC training for the year 2019 and 20. Lordship, sir, with reference to the subject cited above, I have the honor to submit herewith the status of the results of Recorder Certificate Class Course Training for the year 2019 and 20 pertaining to the writ petition number 6958 Dipankar Kakoti versus State of Assam and ORS, and WPC's number 6900 Arup Goswami versus State of Assam and others. In this connection, I like to draw your attention that a detailed scrutiny was initiated to verify the authenticity of the permanent resident certificate by letter under reference. However, following chainmen Dipankar Kakoti of Morigaon, Imsadul Haq Morigaon, Anup Kumar Nath Morigaon, Navajit Hazarika, Lakhimpur, Jiten Saikia Lakhimpur, Biraj Borua Lakhimpur, Dhanya Kumar Medhi Morigaon, Hemanto Medhi Morigaon, Kushal Bordoloi Morigaon, Arun Nath Morigaon, and Sri Arup Goswami and Abdul Kalam Azad, who attended the RCC training 2019 and 20 council batch, by DLR's letters such and such, dated such and such, are otherwise eligible for the training. The result of these candidates could not be declared, as they have appeared in the same examination for the council batch, which is under seal and cover and also under sub judice. The office of the undersigned has no objection to declare the results of the said candidates who are out of this jurisdiction of the BTR and the Mahasau Council subject to the approval of the competent authority. This is for favor of your kind information and necessary action. This is by the principal, Your Lordship. So, Your Lordship, the order page 34, Your Lordship, the order. Your Lordship, page 34 and 35, Your Lordship. So this order dated 1st of December 2022, Your Lordship. It was ordered for declaration of the entire batch result, Your Lordship.
Okay.
But the entire batch result could not be declared because, Your Lordship, firstly, it is a BTR, it is a 6th schedule area, Your Lordship. And also, Your Lordship, only these people who had appeared for the RCC training, this bunch of 10 to 11 number of people, Your Lordship, these are also serving as chainmen, Your Lordship. So, Your Lordship, the letter 911, which was not placed during the hearing of the writ petition, Your Lordship. So what is meant by the 911 order, Your Lordship, only that bunch of people who are also serving as chainmen, only their result can be declared. So there is a reference of this 911 letter in 2411 letter. So, Your Lordship, while passing the order in the writ petition, this 911 letter was not placed before Your Lordship. So the confusion arose, Your Lordship. So the order passed in the writ petition, the disposal order, which was passed in December, Your Lordship, it was ordered that the entire batch result should be declared. But entire result could not be declared because, first of all, it is a BTR area, like 6th schedule area. Secondly, there are people who are not permanent resident of this area, Your Lordship. So if even if some people pass also in this training, Your Lordship, and if the result is declared, there will be a law and order situation, Your Lordship. Lordship has.
Who's on the other side?
I'm representing my lord BTC.
BTC.
I do not have any say, my lord.
Yeah,
If there is-
Petitioners Council, have you served a copy?
Yes, Your Lordship.
M. Sarania,
Yes, Your Lordship.
where is he? Oh, his name is not reflected. Have you served a copy?
Yes, Your Lordship.
Okay, your good name, please.
And Bordoloi.
Third MS N. Bordoloi. Leonard,
Lordship, I'm Standing Council Revenue Department. I have filed this review
Leonard,
petition.
Standing Council Revenue Department for the review petition. Staff register is directed to reflect the name of Mr. M. Sarania as Leonard Council. For the respondent number,
They are the opposite parties. Your Lordship.
for the opposite party,
Respondent number, they will be from 1 to
59.
59.
Yes, ma'am.
For the respondent,
yes, Your
for the opposite parties, 1 to 59
Lordship.
in the cost list. And list the matter again on
Day after tomorrow, Your Lordship.
yes, 31st.
Otherwise, Your Lordship, this is an open and shut case, Your Lordship, because this letter was not placed. Therefore,
That
the
we'll see.
Okay.
Let him come.
Bless you.
Item 6.
Is this a part of matter? Item 6.
May I please, your
What
Lordship?
is this IAVO?
Lordship, this is for modification of the order dated 72/2003 and to allow the petitioner to implement the chief secretary, chairman of the state level committee for competition appointment.
What is
As
the
per
order?
Lordship, that is at page 8, Lordship. Under operating person at page 9, Lordship. Council would it is permitted to implement the state level scrutiny committee, Lord. It should be, Lordship, state level committee for competition and appointment, represented by the chief secretary to the Government of Assam, Lord.
Okay. Anybody for the respondents?
Appearing for the government.
Any objections you have? The
No, my lord.
You're good now?
BK Gogol, Lord.
Heard Mr. BK Gogoi, Learned Counsel for the applicant. Also heard Mr.
Ji Bogole.
J. Bogalia, Learned Government Advocate. For the respondents,
Respond deputy
for
commissioner.
the opposite parties,
I am for 3.
3,
3 and in the I, no, 3 and 5.
3 and 5. Elementary,
I appear for element. Miss Kedas,
MSK Das, Learned Standing Council Elementary Education,
1, 2, and 4.
for 1, 2, and
And
4. Stop. By this application, the applicant is praying for modification of the order dated 17/2/2023, passed by this court in WBC 176 of 2023, whereby the applicant who is the writ petitioner in the said writ petition was permitted to implement the state level scrutiny committee as party respond number 5 in WBC number 176 of 2023. Stop. But Learned Counsel for the applicant submits that the implement prayed for was for the state level committee for compassionate appointment represented by the chief secretary to the government of Assam and not the state level scrutiny committee as projected in the order, as directed in the order dated 17/2/2023. Stop. But I have considered the course shown in the present eye, as well as the submission of the Learned Counsel for the applicants. Also heard Mr. J. Bogalia, Learned Government Advocate, as well as MS Kedas, Learned Standing Council Elementary Education Department. After hearing parties, it appears that the order dated 17/2/2023 was where the implement of the state level scrutiny committee was due to some was, what have you stated?
Lordship, state level committee, Lordship, for competition appointment of first.
Was inadvertently made and accordingly the order dated 17/2/2023 stands modified as under inverted commas. The learned counsel for the petition is permitted to implement the state level committee for compassionate appointment represented by the chief secretary to the government of Assam as party response number 5 in the present with petition by hand in presence of the joint register within bracket judicial and list the matter after 1 week. IA is accordingly allowed.
Deeply obliged.
No orders required
Lordship.
in the main writ petition.
Lordship, that is it was the claim of the writ petition was rejected by the SCLC, Lordship. On the ground that the decision of the
Okay.
Lordship.
May I, Your Lordship? Lordship, in item number 5, I'm informed Mr. Manasaranya has not received a copy of the review petition, Your Lordship. I may be allowed to serve him a copy, Your Lordship, in item 5.
In the item number 5. Per MS and Bordello, Learned Standing Council. Revenue Department for the applicant. Stop.
Review petition.
For the review petition. Stop. Learned Counsel for the review petitioner shall furnish a copy of the present review petition to Mr. M. Sarani, Learned Counsel for the petitioners. For the opposite parties, 1 to 50,
59.
1 to 59. And list the matter, list the matter after, you wanted it on 31st,
Yes, Your Lordship.
31st. I'm not issuing notice, let's see if he
Yes,
accepts,
Your
if he does not accept, then we'll have to issue it.
Yes.
That's fill in. Yeah.